We are indeed grateful to have with us today Shri Ramalingam Sudhakar, President, National Company Law Tribunal, to deliver this evening's second lecture. Sir is serving as President, NCLT since November 2021. He has earlier served as Chief Justice of High Court of Manipur and Jammu and Kashmir. Sir practiced in all branches of law with particular emphasis on customs, central excise and sales tax law. In his illustrious career, Sir undertook several administrative duties besides discharging his judicial work. Sir has been instrumental in implementation of e-courts project and other facilities to the High Court of Jammu and Kashmir and its district courts. We extend a hearty welcome to you, sir, and request you to kindly address the audience.
A warm good evening to all of you. Respected Honorable Minister for Finance and Corporate Affairs, the Chairperson of IBBI, Shri Ravi Mittal, Shri Ashok Kumar Gupta, Chairperson, Competitive Commission of India, Shri Jayanti Prasad, whole-time member of IBBI, my distinguished members of NCLT, members of the Office of the NCLT, officers of IBBI, the regulatory body, members of the legal fraternity, the representatives of the insolvency professionals, ladies and gentlemen. The Mother Earth is the Ministry of Finance and Corporate Affairs. From this, the IBC has come up as a tree as much as the Competition Commission. My dear brother was speaking about the role of IBC, but I also would like to say that while he deals with competitiveness in the market and the commission, the role of the commission in that is one aspect, whereas in IBC, which is our tree, where we blossom as an adjudicating authority, I would say we do the resolution process of healing and empowering. It is appropriate that the Honorable Finance Minister is with us on this day when we celebrate the 6th annual day of IBBI. We have gathered here to look back and reflect on the significant growth of insolvency ecosystem in India under IBC regime and reaffirm our pledge to promote, foster and enable IBC to succeed. Such success will reflect the improvement in quality of corporate governance and show the results that the Ministry of Finance and Corporate Affairs looks forward. Before the advent of Insolvency and Bankruptcy Code 2016, there were several laws which provided for restructuring of debt by virtue of this SIC Industrial Companies Act, Recovery of Debts Due to Bank and Financial Institution Act, Securitization Act, and there was intense legal debate on the question which act was to take precedence over the other. Similarly, laws such as Presidency Town Insolvency Act 1909 and the Provincial Insolvency Act 1920 to regulate insolvency resolution for individuals found no remarkable change in resolution of insolvency as required. The reason behind this is multiple statutes giving rise to various intersecting rights and liabilities, as well as multiple fora for purpose of adjudication which did not address the issue of insolvency and bankruptcy as required. The disjointed statutes, clash of jurisdiction, and extraordinary timelines gave rise to resentment from all quarters, and the need to formulate a workable bankruptcy law became imperative to overcome the cost and time consumed by earlier laws. The statement and objects of Insolvency and Bankruptcy Code indicates that the existing framework of insolvency and bankruptcy law was inadequate and ineffective and resulted in undue delays in resolution and erosion of value of assets. The code was proposed with the objective of consolidating and amending the laws relating to insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximizing the value of assets in distress. The code provides for designation of NCLT and Debt Recovery Tribunal as adjudicating authorities for corporate persons, firms, and individuals for resolution of insolvency, liquidation, and bankruptcy. As we all know, the preamble of the code of the IBC is to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals. The other important factors is to implement in time, maximize the value of assets, increase and stimulate availability of credit, promote entrepreneurship, balance the interest of stakeholders, including the priority of payment to government dues, which of course now is a hot debated issue. IBC is an important reform in our country in corporate governance. The effective operationalization of IBC will improve India's ranking in the World Bank's Ease of Doing Business Index. As adjudicator of issues arising from IBC, NCLT represents one of the most significant limbs of insolvency law. The approach of NCLT will have a far-reaching bearing on the outcome of IBC. The exigencies of the insolvency law and the economic goals required the adjudication of issues arising out of proceedings to be resolved by NCLT not on the basis of technical questions of law, but after considering the policy intention and unique principles on which the law is based. 6 years of IBC, the way forward. IBC places considerable responsibility on IBBI in its role as a regulator as well as for carrying out other functions. The legislature has chosen IBBI as to regulate the insolvency professional. The IBBI has regulatory oversight over professionals and related institutions. The insolvency professionals, professional agencies, professional entities, and information utility. Further, IBBI has the responsibility to make regulations and guidelines on the matter relating to insolvency process like CIRP, prepackage, corporate liquidation process, voluntary liquidation process, fresh start process, individual insolvency resolution process, individual bankruptcy process. Timeline and speed in resolution is the essence of the process under the code. The IBBI being a creation of a code prescribes timelines from day one. It was established in 1st of October 2016 and commenced corporate insolvency by December 2016. The immediate task included market volunteering to set up IPAs, individuals with the right caliber to control the IPAs and seek registration with IBBI as IPs. Regulations relating to IPs, IPAs and CIRP and liquidation process to be in place. Process to spread the message of the code and make the stakeholders aware of the roles. And last but not the least, IBBI to capacity build the stakeholders and work on this. With the active support of the government, IBBI delivered all this, enabling rollout of corporate insolvency possible in 1st of December 2016. Promptitude and speed has been a part of its work culture since then, and it is continuing despite all turbulence during the long and gloomy COVID days. IBBI is different from other regulators as it does not only it develops and regulate insolvency professional, but it also specifies the regulations to be followed by the IPs in the market for transaction and regulate the market where IP serves. It sets standards to ensure quality of service and endeavors to provide competitive environment. Some examples of statutory features that makes IBBI distinct from other regulators are: the code requires IBBI to specify the mechanism for issuing regulations, including conduct of public consultation process. The code provides that the IBBI may constitute advisory committees in accordance with the regulation. The code has several provisions such as requiring IBBI to publish information, data, research studies and other information, maintain websites and such other universally accessible repositories of electronic information, collect and maintain records relating to insolvency and bankruptcy cases, and disseminate information relating to such cases. This is not exhaustive. Achievements of IBBI. The regulator IBBI has been proactively trying to reduce the delay in insolvency process and improve the resolution value. The new introduced amendments in CIRP liquidation regulations are a testament to the same. Information available remained a challenge to the resolution applicants. The board has made changes in the content of the information memorandum, improving it in the process, changed expression of interest format, and now copy of avoidance applications is also made available to the resolution applicants. As regards value maximization, a regulation has been amended to enable market efforts by formulating a strategy under CIRP. But perhaps the biggest change is enabling of resolution of functional and operational parts of CD. It comforted stakeholders to enable resolution plans which contain measures for sale of part of assets of the CD. The board has been forthcoming in enabling a variety of permutations and combinations so that the resolution is achieved and must be commended for the same. The board has also been proactive in improving clarity in CIRP activities. An IP is now required to communicate to all creditors of the company regarding initiation of insolvency. This will enable the process to be more streamlined and further strengthen information availability to stakeholders regarding initiation. It is widely recognized that IPs are the fulcrum around which the entire process. It was thus very important to nudge and incentivize IPs for timely resolution and also ensure value maximization. The board has now proposed a fee structure which is like a performance-linked initiative fee for timely resolution and linked it to resolution value. This will be a great invisible nudge to the IPs to complete process faster and bring value to the table. In liquidation, the amendments have enlarged the scope of stakeholders consultation committee and allow COC to function SEC for the first 60 days of liquidation process. The amendments also provide for provisions for replacement of liquidator. As regards reducing delays, timelines have been introduced for auction events, and board has also proposed auction through auction portals which will enable soon. The newly introduced amendments place greater reliance on technology, and the IM now has provision for geotagging of assets. Going forward, continued reliance should be placed on technology by stakeholders to enable faster completion of the process and prevent value destruction. Challenges faced by IBBI and its outcome. There have been concerns emanating from integration of powers in regulators. Highlighting the concern, the Supreme Court in the matter of Clariant International observed that integration of power by vesting legislative, executive and judicial power in the same body in future may raise several public law concerns, as the principle of control of one body over the other was a central theme underlying the doctrine of separation of powers. Recognizing the concern, the IBBI structured itself within 100 days of its existence into three separate wings, namely Research and Regulation Wing, Registration and Monitoring Wing, Administrative Law Wing, and each of these wings are headed by separate whole-time members to minimize intra-institutional and public law concern. The kind of proactivity engaged by IBBI has with stakeholders through hundreds of roundtables every year has been unprecedented in many ways. The active role of the stakeholders have played its commendable turning out to be most valuable resource of the IBC ecosystem. IBC is a reform for all the stakeholders by the initiative of Ministry of Finance and Corporate Affairs, Government of India. Further, the statutory process of making regulations and organization structure of quasi-legislative, executive and quasi-judicial wing component under the IBC help build credibility to the regulatory body IBBI. From my interaction with IBBI, its chairperson, executive directors, I can say with certainty that IBBI is constantly learning and upgrading its skills. Every interaction with the stakeholders improves the insolvency ecosystem, bringing new learning and understanding. IBBI is also making efforts to encourage research in insolvency law to help make better and informed policy decision going forward. We at NCLT is one such prime participant in this process evolution. Concluding, the achievement of IBC in this short span of 6 years have been noteworthy and considerable. It is reflected in the improving ranking of our country on ease of doing business. The code has been heralded as a game-changing legislation, and rightly so. The code has come a long way since its enactment in 2016, meandering through myriads of challenges, and in the process it has won many accolades. In short period of its operation and functioning, the consolidation of the statute was closely synchronized with the development of insolvency ecosystem. The speed with which the entire ecosystem was geared up has been astounding. The primary objective of the code is rescuing firms from distress which is visible. At this juncture, it will be my duty to place the proof of efficacy of IBC in the framework of NCLT in the IBC regime. I would like to draw the attention of Honorable Minister for Finance and Corporate Affairs. The status of case with NCLT in respect of section 7, 9 and 10 and 94 and 95 of IBC cases are as follows. The data which already provided, we have already got it uploaded in the system, but I will only say this. The percentage of adjudication of cases under section 7 is 79.86%. Section 9 petition, the percentage of adjudication is 83.72%. Section 10 cases is 93.94%, and the average of 7, 9 and 10 cases adjudicated by this authority is in the range of 85.4%. The total amount involved in the cases disposed of under section 7, 9 and 10 settled before the admission, that is after a preliminary hearing, is 7,21,000 crores. Settled after admission under section 12A, 24,601 crores. Resolution plan approved 3,03,381 crores, and the total is 10,49,265 crores. Amount realized under section 43, 45, 49, 66 during liquidation, section 94 and 95 are not included in this figure. Insofar as it may be not relevant, but however, I'll just for the sake of completion, because we are also donning the role of company court. So, insofar as section 230 and 232 cases, which is basically in corporate line, merger and acquisitions, out of the number of cases filed, pending and disposed of, our target achievement is 93.29%. I am sharing the above data to indicate that the scope of adjudication under IBC has been rewarding and result oriented. This will dispel murmurs at different quarters that all is not well with NCLT. This is despite several apparent and noticeable shortcomings like periodical reduction of members, presently 28 out of 63, and infrastructure which requires to be improved in metropolitan cities like Bombay, Delhi, Chennai and Calcutta, and of course staff which are still in the anvil before I took charge on November 21. This, however, does not deter us from our commitment to the code and the role of adjudicator in effective corporate governance. I thank all the past president members and the present members for their active role in coordination with the IBBI in achieving this target. I cannot take it for myself. I speak for the NCLT as a whole. The Insolvency and Bankruptcy Code thus emerged as a life-sustaining legislation which provides a new lifeline to rescue company distress. On this 6th annual day of IBBI, I wish the board the very best in its endeavor to realize the true potential of the code and commend it with its contribution towards realizing the Ministry of Corporate Affairs' objective of improving corporate governance and ease of doing business pan-India and globally. The dream of becoming a $1 trillion economy envisaged by the Ministry of Finance can be achieved only if all the stakeholders show their commitment in implementing IBC. On behalf of NCLT, we assure the Honorable Minister of Finance and Corporate Affairs our commitment towards the objective of the code and seek Government of India's cooperation for effective functioning of the adjudicating body. My best wishes to the Chairman and members of the IBBI board. Thank you.